welcome to our private wealth webinar this morning. As I say, I'm Caitlin Jenkins, partner at Mills Reeve, and I'm joined this morning by two of my colleagues, Anna Moore from our private client team and Frances Bailey from our family team. And today we're talking about protecting family wealth. So passing wealth down through the generations of a family in a tax efficient and protective way. And it's a focus for many of our clients. So we thought it would be useful to have this conversation about the pros and cons, some of the risks, some of the advantages. Now, a couple of practicalities. As it's more of a conversation this morning, you might be worth you putting your screen on gallery view so you can see the speakers. And if you've got some questions, please do put them in the Q&A function. We'll try and answer them at the end of the discussion. We're hoping the discussion will be about 30 minutes and we'll try and do some questions afterwards. Yeah, so please do put them in the chat function, the Q&A function, and we'll do our best to answer anyway. So let's get started. Frances, Anna, thank you for joining me. Scene setting. So we're talking about protecting family wealth. Let's imagine a family, for example, mum and dad have built up a business, they've got several children, parents are now thinking about handing money down to the next generation. We're talking about that sort of context. So first of all, why is succession planning important? Let's come to you first, Anna.
Well, when we see clients, if they've amassed quite a significant amount of wealth over the years, they've worked really hard for it, then they'll naturally get to a stage where they think about, well, most of them will, where they think about stepping back and bringing in perhaps the next generation or whoever they want their wealth to pass to in the long term. And it's really ideal where they do that in a really measured and considered way, because really, less ideal is where they get to the end of their life and they die and they're just still sitting on all of it and they haven't really given any thought to how it's going to progress down naturally and in a really controlled and measured way.
So what do clients tend to be worried about? What are their primary concerns when they're thinking about succession planning or wealth planning?
Well, I think in private client, I mean, we focus on inheritance tax a lot, but quite often for clients that's not and in fact shouldn't be the first focus. I mean, really, it should be who they want to get to pass these assets onto and how they want to do it. And then it's our job to essentially work out the most inheritance tax way of doing it. So some clients are more tax focused than others naturally, but really it's all about how, why and when really, and then the tax kind of comes along naturally, hopefully, and that's our job to make it tax efficient. So what we commonly hear from clients is quite often, particularly where you're talking to the wealth generators, if they've built it up themselves, naturally they're quite protective of it. They want to make sure that when they pass it on, they do so in a way that it's going to endure for generations of their family. So quite often it's all about control for them. So how are they going to pass it on in a controlled way? And quite often that's them maintaining a level of control, but quite often often it is just picking who's going to have the control in the future and really thinking about that. And kind of linked to control and this idea of the family wealth enduring is the protection side of things. So how are they going to protect that wealth against attacks, sort of external attacks, and Fran will talk about this, but also protecting from sometimes family members. So how to help family members look after the wealth that they're going to be given.
Great, thanks. So thinking about some of those potential attacks, one of the obvious ones is the possibility of this mum and dad handing money down to the next generation, and then there's a relationship breakdown. So Frances, coming to you, what are the risks of that, is sort of in very general terms, of say a divorce of one of the future generation who's being handed some money?
Yeah, so to contextualise the risk there, the first thing to say is that the family courts in this jurisdiction, which is England and Wales, have very wide powers to redistribute assets on divorce. And they have a very wide discretion as to how they exercise those powers. All they're directed to do under the Matrimonial Causes Act is to take into consideration all the circumstances of the case and a specific list of factors, such as kind of age, extent of wealth, health, contributions, etc. With first consideration always being given to the welfare of any children. So the risk there is that if assets are passed on to future generation, and there are various structures that we will of course explore. If those assets fall into that future, that child's kind of estate, as it were, for the purposes of the Matrimonial Causes Act claim, the family court has the power to transfer those assets, to order sales of those assets, to take into account that wealth when ordering a lump sum payment or a maintenance payment to a non-family member who's married into the family. So that's the risk that a lot of our clients are kind of keen to protect against.
Okay, so there's a lot for this notional mum and dad who are thinking about handing money on to the next generation to think about, both in terms of their priorities and in terms of what level of control they want and in terms of future risks. So let's dive into and look at some of the possible options that we might, as a team, explore with these clients. We've got 4 basic things we were going to think about, I think. So the first one was to think about absolute giving. So in our example, mum and dad have some investments they're considering to give to one of the children. So from a planning perspective, Anna, absolute giving, what does that sort of look like from a planning perspective?
Well, I think the beauty of absolute giving, so that is literally just deciding that a client doesn't want their assets anymore, doesn't need them, and that the time is right to pass them on to whoever, often the children. Now, the beauty from the private client perspective is the simplicity of this. So, I mean, you have to do it in a proper way, take advice and make sure your documentation's in place, but it is essentially very simple, and therefore the tax consequences are quite easy to understand. So generally, if you do it correctly, you give it away, you survive for 7 years, and it drops out of your estate for inheritance tax purposes. So nice and simple from an inheritance tax perspective. I think you mentioned investments there, Caitlin, and I think that's interesting because when a client is thinking of undertaking some just simple giving, then I think top tip is to watch out for the other taxes, because particularly cash is nice and simple and great if somebody's got a chunk of cash to give away. But with investments, things like that, particularly you have to watch capital gains tax. And if you've got shares, then look out for the other taxes and land SDLT. So there's always the other things to think about, but it is essentially nice and simple.
Yeah, good point, actually, because it isn't just about inheritance tax planning, is it? It's about the broader implications immediately as you pass on the asset. So, Fran, coming to you from a protection perspective, mum and dad do decide to hand this asset or some cash down on a sort of absolute gift to one of their children. What's the implications of that from a protection perspective if there were a divorce in the future?
Yeah, so I think absolute giving is probably the prime example of where the private client perspective of potentially being the most tax efficient and the family law perspective are most at odds, because if wealth is passed on and so it is absolutely so legally and beneficially with the child, then fundamentally that is their asset. It is a resource that the family court is going to take into account when dividing up the overall kind of pot of assets between the divorcing couple. That doesn't mean there's not arguments that can be used, and a common one that often features in high wealth cases is drawing a distinction between what is commonly called matrimonial assets, which is effectively the accrual from the matrimonial partnership, regardless of who's gone out and earned it, and non-matrimonial assets, which is inherited wealth, premarital wealth, and sometimes post-separation wealth if there's been a long period of separation. So there's always an argument that, say, wealth passed on from parents, as in our example, is non-matrimonial in nature and therefore shouldn't be subject to the sharing principle that would otherwise kind of generally dictate a starting point of a 50-50 division. However, in a case where it's more modest assets, that is not going to succeed, because in a more modest asset case, everything is probably going to come into play to be able to be used to meet needs. And equally, we often find that over time, assets get mingled. It's quite rare for people to receive wealth and just keep it in a separate account, very separate from everything else. It might be intermingled with monies in a joint account. It might be used to fund an extension to a house or something like that. And all of that treatment over time starts to water down that non-matrimonial nature. Just a quick word about, say, shares in a family business, because I think that is slightly different. For a start, it's much easier to pinpoint those and effectively ring fence them as a non-matrimonial resource. And secondly, there is potential for there to be kind of safeguards and protection within all the corporate documentation, which we will talk about briefly, I think, at the end of this session, in terms of preemption right, restrictions on transfers, etc. So that is sometimes easier than a kind of cash lump sum that passes to someone.
Absolutely, you're right. And we're talking at a high level about these different options, but there are sort of drilling down into the different options, what might be work for business assets or shares in a business or cash or investments. There's different implications. So you're absolutely right to flag that. And likewise, I think at Mills Reeve, we all recognise that often there is a conflict between what the tax advice might be and what the family law, if you're worried about future divorce or separation, might be. And I think the thing for us is just so that the clients and advisors understand those two implications, and then clients can make informed choices. It's not that one is right or one is wrong in terms of an approach. It's just balancing up to what the clients have in mind and what their concerns are. So, okay, so that was giving. So the second sort of general option we wanted to look at was lending. So mum and dad in our scenario aren't quite ready to give the asset away, but they're happy to lend to one of the children, for example, a chunk of cash. The classic is usually to help buy a house. So from a planning perspective, Anna, how does that look like? What are the sort of general implications for that?
Well, I mean, you've already alluded to this, but it definitely is a slightly different focus. So quite often when clients are wanting to give away in whatever way that looks like, then the focus is because they've made a decision that the time is right for them to start doing that. Whereas sometimes there's quite a different focus with lending, because it's sometimes recognising that there's actually a need, particularly for a child, that perhaps, as you've said, they're buying a house, they could get a mortgage, but sometimes if the parents are sitting on the cash, then that doesn't really make sense for them to go away and pay somebody else to buy the house. So it comes from a different direction, if that makes sense. From a private client perspective, in terms of succession planning, I mean, there's definitely a place for it, and we do loans to children all the time, but it's not as inheritance tax efficient, because you're not actually giving anything. Well, you might be giving the growth away depending on the terms of your loan, but you're not giving your chunk of capital away, because of course with a loan you're entitled to it back and it remains an asset in your estate. So from a private client perspective, purely looking at inheritance tax, it's not great because it doesn't reduce your estate. But then, of course, as I've said, there are wider implications for families, and it does definitely have a place.
Thank you. So then from a protection perspective, Fran, I suspect it's a slightly different view in terms of the advantages.
It is. And if it's done properly, it's probably the safest way of helping a child out from a kind of protection from relationship breakdown perspective. But the key there is it has to be done properly. So any loan that's being advanced should be properly documented. There should be full consideration given to what the terms of that loan are. When is repayment due? Is interest due? When is interest payable? What happens if the child wants to sell the property? Does it roll over into a new one, etc.? And most importantly, that needs to be documented, but it also needs to be lived. So they need to abide by the terms of their document. The risk, if they don't, is, and you and I have both seen it in numerous cases, Caitlin, that you come to a relationship breakdown, and the child who received the money says, well, that money was a loan from my parents, we owe it back. The equity in the house is actually only £500,000 because we owe mum and dad £1 million. And the spouse says, well, no, they gave us that. So the equity in the house is actually 1.5 million. And you end up having the parents having to be joined into the proceedings, means there's 3 lots of lawyers. The potential for kind of disruption to the family dynamic is vast. And that can be avoided if everyone knows and is clear about what the terms of that loan is at the beginning, and they subsequently abide by the terms of that.
Absolutely. So good protection from a divorce perspective, a subsequent separation perspective, but only if it's done fully and properly. And I would echo that. I think that the biggest thing about the whole helping a child buy a house thing is for the parents, usually the parents, not always, but to be really, really clear about what it is. Are you giving the money? Are you lending the money? Or are you actually buying an interest in the house? And it's remarkable how many times that isn't clear, or they think it started off clear over the years and the waters have got muddied. So yeah, lots of pros and cons to lending, but it's an important one to get advice on, I would suggest. So that's our second.
If I can just, sorry, I was just going to put an interesting point I thought of actually was, it could start off as a loan, and Fran probably won't like this from a from a family perspective, but it could start off a loan, say if the parents were unsure about a relationship a child is, and then of course a number of years down the line they could decide to release that loan, and then of course that becomes an absolute gift. So with all of these types of planning, there is a measure of flexibility, you know, that it can evolve over time, but obviously, as Fran said, keep your documentation up to date and make sure you're recording what you're doing. And
that's where prenups or postnups might come in, and we're going to come to that later. We've had a question about prenups, so thank you for the question. We will come to it. So the third area we're just going to touch on, and I'm conscious of time, is use of trusts. So from a planning perspective, do we still like trusts, Anna? Are they still useful?
We do still very much like trusts in private client, yes. I mean, they have their downsides and their restrictions, but we do still find them incredibly useful, and we in fact use them all the time. So the big advantage of trusts is that it allows clients to make a gift. So they are giving something away, but they're not giving it absolutely. So they're putting it into this really protective and flexible structure. That key for a lot of clients is that it allows them to retain control. So it's not always the case, say in our example, that the parents would be the trustees, but I'd say probably 90% of the time it is. So it allows them to park those assets essentially and carry on having a say in what happens to them. So when they're acting as trustees, it is very much acting with a different hat on. They have their fiduciary duties, and you know it's very clear that they must act in a particular way, but they can decide how and when they want to pass that wealth on. So they're incredibly useful for that. I mentioned the restrictions. I suppose the big restriction on trusts is how much you can get into them. So, I mean, this is a whole seminar in its own right, but very briefly, I mean, you've got your nil rate band, so you can get assets up to your nil rate band. If you've got relievable property, so business or agricultural property, you have more scope for getting assets into trust. And then there's things like the surplus income exemption, which can be really useful. But it's not the case that you can just take 2 million and stick it in a trust. That's generally not possible during lifetime. So that's the big restriction. And also, Fran will come on to this, but again, it's all about the documentation. It's all about getting it right when you set it up, and then making sure as you carry on that everything is done correctly and everything's recorded that should be.
Great, thanks. So trust is still around, still a useful tool in the toolbox, as it were. And interesting, it sounds like for families often it's a method of handing something on, but sort of retaining a bit of control or at least structure around an asset. So Fran, what does that look like from a trust look like from a family law perspective?
Yeah, so the key thing to note here is, and it might come as a surprise to some on this call, the courts do actually have the power to interfere with trusts on divorce. So they are not as watertight as people think they are, subject to the fact that it's very difficult to vary a trust and it's very expensive to vary a trust. So it is seen as a option of last resort by the family courts, really. A trust is only variable by the family courts if it's nuptial, if it's a nuptial settlement. Although rather frustratingly for us all, there's no definition of what a nuptial settlement is in the Matrimonial Causes Act. And the court's guidance is simply that a trust is nuptial if it benefits one or both of the parties or the children and is created because of or referring to the marriage. So it's fairly kind of potentially wide definition there. Reality, though, as I mentioned, is that varying a trust is an expensive option and it's an option of last resort by the courts. They will generally look to do anything else if there are assets outside of the trust, and so the solution there is that they might well look at the assets available to the spouse beneficiary, take that into account as effectively their award, and order a greater share or perhaps the entirety of the non-trust assets to the non-family member spouse. So that's a way that's quite often kind of the solution to these cases. In some cases, courts do make orders that actually the beneficiary spouse wouldn't be in a position to to implement without going cap in hand to the trustees and the trustees putting them in funds. It's something called judicious encouragement. It's not the ideal solution if you're acting for the non-beneficiary spouse, because you have all sorts of enforcement difficulties if the trustees don't actually pay out to the beneficiary spouse to enable them to pay. But that is also one of the options there. The key thing, and Anna alluded to it when she mentioned documentation, is that when the court are looking at the trust as a resource in a family court, they're going to look at not only what the trust says, but also the history of that trust. So when the beneficiary has previously asked for money, has it been granted? Have the trustees acceded to requests from that beneficiary and from all beneficiaries? Because they need to look at the reality of whether or not that money will be made available. So it's really key for trustees to be keeping clear minutes about decision making, to be kind of abiding by the terms of the trust, obviously, but also kind of the spirit of the trust, any letters of wishes, etc. And as so much of it, as with the loans, it comes back to the reality of how something's been treated in practice, not just the kind of legal documents in place.
Thank you. And I think it's interesting, isn't it? There's a theme coming through from basically all of these different sort of options, and we'll come to the last one in a second, which is it isn't just about the decision at the time, it's that following it through. So the decision, the sort of collective family decision about what they want to do, then documenting it, and then following it through in terms of documentation. So it's all of those things. It's a sort of ongoing discussion. So the final area we're going to look at, and then we'll look at some overarching points, is what I used to call the new kid on the block, the family investment companies, which have been around a long time now, so I can't really call them that, but family investment companies, and often in some circumstances sort of taken over from trusts, but not always. So family investment companies, Anna, what are their pros and cons from a sort of planning perspective?
Well, I think we act for a lot of business owners, and so quite a few of our clients and will be very comfortable with companies as a structure, so they know companies, and in many ways it's a similar idea to trusts, as in they can give assets away, but because of the structure of a company, they can very much set out who's going to have control, who's going to have beneficial interest. So by making sure that they appoint the correct directors, which might be themselves, they can decide who's going to control this company, and therefore who's going to control the flow of dividends and all that kind of management of the wealth within the company. And what they're essentially doing is giving money to, say, the children in this case, to allow them to buy shares. So they are passing on that wealth, and they're sharing wealth. So it's it can be a real family enterprise. Now, I think Fran did touch on this, but with family investment companies, what it gives you the opportunity to do is make sure the articles offer protections. So quite often we're looking at things like really restricted share transfer rights to make sure that shares can't be transferred to non-family members. They quite often allow them to be transferred to trusts and family members, but nobody else. There could be shareholders agreements requiring any shareholder to have a prenuptial or postnuptial agreement. So all this kind of protection when you guys have to get involved, it really helps when you're looking at the shares to give you some ammunition to protect them.
And family investment companies are a bit more flexible on what sort of asset you can put in as well, aren't they? Whereas trusts a bit less so, is that right?
Yes, that's right. So you're not restricted on value, essentially. So yes, that is a key point, Caitlin. Yes. Whereas trusts, it's difficult to get sometimes difficult to get large sums of money in. You're not restricted in that way with family investment companies. And in fact, we quite often use them together. So we might, a client might set up a family investment company, maybe keep some shares themselves, maybe not, pass some shares on to the children. You can use bare trusts for minor children or grandchildren, but you can also put a chunk of the shares into a family trust. So you're really kind of spreading the risk and spreading the wealth. What's quite useful actually is if you are putting shares into a family trust, that can sort of make future provisions for, say, grandchildren that haven't come along yet. So it's very flexible.
Absolutely. So Fran, family investment companies from a protection perspective, a divorce perspective, what's the thoughts there?
So the first thing I'd say is I'm not aware of any cases that have specifically been on the issue of treatment of family investment companies. I'm sure they have featured in cases, but they've not been kind of the key reported issue, as it were. But kind of there's obviously been a myriad of cases about treatment of family businesses, so trading businesses. And we can draw some kind of guidance from those in a way. The first thing to say in relation to family investment companies is that, unlike trusts, if a family member holds shares in the family investment company, they will be both the legal and beneficial owner, and therefore it is fundamentally their asset and comes within the court's redistributive powers under Section 25 of the Matrimonial Causes Act. So in that respect, they're less good unless you have the kind of interposition of a trust structure within the family investment company shareholders, as Anna talked about. But in that respect, they're less good than a traditional trust model. However, with the benefit of kind of articles of association, shareholders agreements, etc., that perhaps set in levels of protection about who can own shares, then that may well prevent shares in the FIC being transferred out to a spouse and therefore coming outside of the core family members group. That doesn't prevent the value of that shareholding being taken into the court, but obviously there's then still all the arguments about non-matrimonial source of that asset, meaning it should be treated differently from a court by the court unless required to meet needs. So there's kind of levels of protection there.
Great, thank you. So, conscious of time, because we have a few minutes left, and then we'll try and take questions, because we said we'd try and do this session for half an hour or so. So those are the kind of the 4 key areas that we thought we'd just have a look at, pros and cons, as you've heard of both. But there are some overarching things, I suppose, some top tips that also it's really important to think about in this context. Coming to Fran first, prenups, post-nups, and then also, I suppose, the situation when people aren't actually married.
Yeah, so pre and post nups is something we're seeing increasing amounts of instruction on from a variety of clients. I think they no longer hold the kind of stigma they used to. Certainly they're no longer considered void for public policy reasons, which they used to be. So my view is a pre or post-nuptial agreement is essential for any kind of family of significant wealth and works alongside all the other wealth protection structures. So it's very much a belts and braces approach. Parliament has not legislated to make them binding, so they are not necessarily a slam dunk, but they are going to be a magnetic feature under that discretionary exercise. And the current status of them is following a 2010 Supreme Court decision that effectively provided certain procedural safeguards are met. So there's legal advice, financial disclosure, they're not kind of rushed into the day before the wedding, generally 28 days before the wedding ideally, and provided it's not substantively unfair, which is generally taken to mean it must make at least provision for needs. Needs is a slightly elastic concept, of course. The agreement should be determinative of that discretionary exercise. So it can work alongside the trust, it can work alongside the family investment company, which, as Anna said, the shareholders agreement may require a prenup in place in order to get shares in it. It can work alongside a loan agreement, especially if a loan's being written off. It can work alongside absolute giving. I think it's a really key thing that all families of wealth should be thinking about for all members. On the non-marriage front, very briefly, very complex area of law. Unlike Scotland and many other jurisdictions, we do not have automatic rights for financial provision on the breakdown of a cohabiting relationship, but there are claims for any children of an unmarried couple, and there are claims in relation to property. This generally is something that we end up discussing with families where they are looking to gift or loan money to help a younger adult get on the property market, and they're potentially going to be moving in with a new partner. What you want to be crystal clear is that everyone understands the basis on which that new partner is moving into the property and the basis upon which they are making any financial contribution towards bills, etc. A cohabitation agreement in that circumstances can be used to set out that nothing that partner moving into the property does, whether it's paying bills, whether it's carrying out renovation works, etc., is intended to give them a beneficial interest in that property. So heads off at the pass what could be really expensive and quite complicated property law proceedings under what's called the Trust of Land Act.
Absolutely. So I suppose the top tip for a cohabiting couple, because we've got a question about cohabitation and what if the party, the givers or the receivers are cohabiting. I suppose the overarching view would be it's very complicated, and you need to don't
Yeah.
assume that the situation that exists between a couple who are unmarried is the same as the situation that exists between a couple who are married, whether that's the giver or the receiver. Just going to come to Anna in a sec about overarching points as well, a couple of overarching points from the private client perspective, as well as the sort of particular ones we've looked at. I suppose the other thing I was just going to mention was the lesser cousin of the prenup is the postnup. So you can have, in effect, what's a premarital agreement, but during a marriage, so a post-marital agreement, particularly important if, for example, wealth is being handed down and the children are already married in established relationships, or in Anna's example of something was a gift and then it becomes something was a loan and then it becomes a gift. So you could have a post-marital agreement to reflect that at the time. So just bear in mind, I suppose, those overarching things of prenups, postnups, or cohabitation agreements. And finally, Anna, before we get to questions, a couple of overarching things from you. So the one, stating the blindingly obvious, but we always have to state it, have a will, get some wills in place as well. And there was something else you wanted to just touch on, which is family charter, I think.
Yeah, so it's this idea that sometimes within a family you've got individuals who have who have lots of different interests going on. So if you take the example of a business, so you may have some family members who are directors, so controlling the business. You might have some that are directors and shareholders, some that are just shareholders, but you may have some family members that are just working in the business and perhaps hoping to get some shares later in life. So, and then you may have beneficiaries of trusts. You've got lots of different, in big families, lots of different things going on. And I think, particularly if there's multi-generations, I think it's easy to assume that everyone knows what's going on. I think particularly if you've got some individuals at the top who are sort of still controlling it all. So sometimes, bringing everyone together and actually sitting down and agreeing as a family what these different rights all look like, and it's all about managing expectations essentially, and brutally sort of making sure everyone's on the same page to sort of head off any problems before they happen. So ideas such as like family charters and things like that, it could be quite a big exercise for a family to do this, but actually making sure that everybody understands how the family wealth is working, how it's passing on, and who's entitled to what can be incredibly valuable in some cases.
Great, thank you. Well, it's just after 10:30, and we said we'd try and keep this session to half an hour. So to the participants who feel they need to drop off, please feel free, we won't be offended. But for those who want to stay, we've got a few questions that we'll try and get through. Just in the next 5 to 10 minutes, but feel free to drop off if you don't. And any questions that we don't manage to pick up, we'll try and respond to separately. One of the questions was about the effectiveness of prenups. So I think we've addressed that. The headline is they are now worth the paper they're written on if they're properly negotiated and discussed, and are much more normal. One of the questions was, how do courts view loans that look like soft family loans? I suspect that's in the context of divorce. Fran, I'll come to you. I suspect that the answer to how a court views a loan that looks like a soft family loan slightly depends on the nature of the loan, and we're going back to documentation as well, I suspect. Do you want to add anything on that, Fran?
Yeah, I mean, that's the debate that so often is had in the family courts. Is this loan a soft loan or a hard loan? And actually, I think even one that's properly documented is at risk of being treated as, quote unquote, a soft loan. And I think by that, what I mean is that the court is probably likely to say, okay, that does reduce the value of assets against which I can make distributive awards. So, for example, couple of a house that's 1.5 million, £1 million was lent by the parents to buy it, but it is documented. So that the assets available for distribution are only £500,000. I could still see a court in that situation saying, okay, I've only got the power to deal with that £500,000, but I'm going to give all of it to, say, the wife that married into the family because she needs it to rehouse, and I don't need to worry about the husband's housing needs because I would expect his parents will effectively roll that loan over into whatever house he chooses to buy, which is slightly different from the court disregarding the loan altogether and saying, I'm going to treat myself, judge, as being able to deal with this full 1.5 So I think there's kind of different stratas of how a court can treat a loan. One is that they disregard it altogether. One is that they take it into account and they assume it's got to be repaid. And then the middle ground is the fudge that we quite often do see them doing, which is effectively saying, look, it's going to be there to meet your needs, but I'm not going to invade it.
I think terms are quite interesting as well, and careful consideration of the terms. And this is always a bit of a tension, because I'm guessing from your perspective, you'd probably prefer to see, interest payable, everything very, perhaps a charge on the property, all that kind of helps make it more commercial, doesn't it?
Yeah.
But from when we're drafting them, what we quite often get from clients is actually they don't want interest. It's just adding a slice of tax that otherwise they wouldn't have to pay. And taking out a first or second charge is costly and probably seems a bit pointless to them. So there's definitely a tension there and again, it's all client specific, isn't it? How important is protection to them? Do they just want to do the best they can reasonably, or do they want to go the whole hog and try and make it as commercial as possible?
I always think they've got to weigh up. Divorce is only a possibility. So divorce of that child is only ever a possibility. Paying tax on, for example, the interest you receive back is a certainty. Yeah. So they've got to make their own choices, but they've got to be aware of the repercussions of each of those choices, I think. And you're certainly right that the more commercial terms a loan has, the more likely it's going to be treated as a kind of hard commercial debt by the family court.
Absolutely. So another question we had was, do the family courts view a discretionary trust as a resource when it regularly distributes money to a beneficiary? I think we can probably, so the short answer to that is probably, well, yes, but probably to the extent to which the beneficiary has received money. The classic is school fees. Mm-hmm. If a discretionary trust has paid school fees for some grandchildren forever, and then there's a divorce of parents, then unless there isn't enough money in the trust to carry on doing that, obviously, because it would have to be viable, then the court is likely to assume, can't order it, but is likely, in certain circumstances, but is likely to assume that that trust will carry on paying the school fees for those children, I suppose is the sort of general answer to that.
Yeah,
one.
And most people don't have a problem with that, do they, Caitlin? What they have more of a problem with is the idea that that's somehow going to open up the trust as being used to settle the non-family member's divorce claim. And then you get into the arguments about, is it going to be available to the family member spouse for them to meet their needs, and or for them to fund a financial settlement to the other one, and or is it a nuptial settlement that's capable of variation, which is a 2-hour talk in itself. Absolutely.
And we've got some quite specific questions about tax in certain scenarios, which I think we might have to pick up separately, because I think we're nearly 22:11 and we said we'd finish by 10:22. So, but one last question we've got, which is, what's the top tip for getting people to accept the need for agreements such as pre and post nups or cohabitation agreements when they're often relatively early in a relationship and still in the full bloom of romance? That's a good question. It's one we're often asked. Fran, do you want to give your top tip?
Yeah, I mean, they do come with a health warning. They're not the easiest discussions to be had when people are, in the flushes of first love and don't think that theirs is going to be one of the relationships that ends in divorce. I think they come as part and parcel of a just discussion and being upfront about money generally. And I think we are still a little bit too British in talking about money, how we're going to handle our financial affairs during the marriage, who's going to work, who's going to look after the children, all of those sorts of discussions. And I guess the other top tip is people are more alive to the benefits of them when they've seen the difficulties that can be caused when there isn't one with this discretionary, uncertain court-based system we have, and the costs that come with that. It's why so often, I don't know about you, Caitlin, but I often end up doing them for couples embarking later in life into a second marriage, and they don't carry with them that same emotional weight because I think they've lived the experience before and they know the benefits. So it's almost a little bit of a scare tactics that this is how it might go wrong if you don't take control of the situation now. And it's also just encouraging open, transparent discussions about money from day one.
If I could just jump in, I think from a planning perspective, so I mean, sometimes we're seeing it at an earlier stage. It always seems to me that it's so much easier if it's not personal. Yes. So if you've already got your shareholders agreement in place saying every shareholder has to have a prenuptial or postnuptial agreement, then it's not personal to that couple, is it? So it's a much easier conversation, saying, you know, mum and dad are going to give me some shares, but actually it's required by the company that in order for them to give that I have to have a prenup. You know, they don't have nothing against you personally. That's a much easier discussion.
Yeah, and we've certainly seen trustee clients, and we've advised our private client colleagues and our trustees about kind of having a trust policy that all beneficiaries should have a pre or post-nup if they're getting married, cohabitation agreements if a partner's moving in, etc. And you're right, that kind of blanket policy is just really helpful in taking away that kind of ickiness. That's a not very legal word around the conversation.
We all know what you mean, though. I think the only thing I'd add to that is sometimes you see them in family charters. That point that Anna was mentioning about a family charter, a family constitution. If you've got a family that's now quite dispersed, you know, business has been down several generations and there might be 30 or 40 shareholders, having a family constitution or a family charter that says various things, including, and this is how we do things around here, we have a prenup if we get married, or we have a cohabitation agreement. So that's another way of getting it in. And also the other way, I think, is the whole wills conversation. So you're getting married, you need a will. And if you need a will, you need to see a solicitor, or you need to think about various things. So what happens in death, what happens in separation. So I think sometimes the wills conversation can be a way into.
Yeah.
Great. I think we're going to have to leave it there now. We have got some outstanding questions. We will do our very best to capture them and get in touch with those, if they're happy to do so, who've asked those questions, just to pick up on some themes and some specifics. There'll be an email follow-up that will come round with our details. If you've got any general questions arising out of this or specific questions, do give us a call. We're very friendly, very happy to be phoned. Get in touch with us and we're happy to try and help. But I think in the meantime, thank you very much to Francis and to Anna for joining the discussion. Thank you very much to all those who joined and participated and asked the questions. And we look forward to seeing you at the next of our webinars about private wealth issues.